Today we're going to jump back into the topic of estate planning with a discussion on something that nobody loves, but everybody needs to know about. We're talking about probate. Now, a lot of our viewers maybe have had to deal with the headaches of probate and the probate court. Yep. But for those of you who haven't and are maybe new to the topic, we are going to answer 3 basic questions today about probate. Number 1, what is probate? Number 2, why do you want to avoid it? And number 3, how do you avoid it, and what are some strategies that can help you with that?
So Amber, let's put on the screen here a definition of what probate means. Probate means simply to prove. Probate is the legal process through which a deceased individual's will is proved in a court of law. Their assets are inventory, debts and taxes are paid, and property is distributed according to their will. Or, if they die without a will, it's distributed according to state law. Now, Amber, we get this question every time we present this topic in the public, and that is, wait a second, you mean if I have a will, it goes to probate? And the answer is?
Yes.
100%, right? A will is simply a piece of paper until it goes to the probate court, and the probate court says, yes, this is a valid will for this individual. So we like to say that the will is your ticket to probate.
So when someone passes away and they have a will or not, probate court is the process by which anyone has to go through unless you've taken certain precautions.
Now, not all assets will go to probate, right? Remember, the probate means to prove. So to prove either who owned it and or who's entitled to receive it. So certain assets with named beneficiaries will not go to probate. If you have a retirement account that names your spouse and then your children or other beneficiaries on the contract, then that's how it will proceed. There's no need to go to probate. So probate is for these assets where either title is in question or who should receive it is in question.
So this doesn't include property that's owned jointly. For example, if you own a property or real estate with your spouse and that is owned jointly in both of your names, that's not something that is subject to probate.
At the first death.
At the first death.
At the first death. At the second death, it certainly could be. So Amber, let's not get bogged down too much in which assets can or can't go to probate. Let's talk about why you would want to avoid probate.
The first problem with probate is that it can be very time consuming. Now, when we do lectures for the public, we often ask people, who has dealt with probate? How long does it take? We often get the response of 1 year or 2 years or even longer. Yeah. So it can be very, very time consuming. And for those who are beneficiaries who are waiting for an inheritance, that is not good.
Not pleasant. Now, Amber, perhaps one of the classic cases of this, there are many, but a recent one is Prince. Prince passed away about 7 years ago. He died with no estate plan, no will, no other estate plan. It took 6 years to sort out who would receive his assets. 6 years is certainly time consuming.
Another problem with probate is that it can be very expensive.
You have court fees. You have to publish in the newspaper and pay those costs. Of course, attorney's fees. Attorneys love probate, especially when they last for 6 years and they're charging by the hour. They love that. Very expensive.
Corey, you mentioned that it has to be published in the newspaper. What does that mean?
Well, when a probate is started, an announcement has to be published in the local newspaper, and it's also a matter of public record. We know how long Prince's estate went through probate, and we know what assets he had, and we know who he owed money to, all because it's public record. Probate is a public record. You can go down to a probate court and open the probate of anyone famous in your hometown. You can find that out. It is all a matter of public record.
But one thing that you should know about probate is that it is almost entirely avoidable if you take certain steps.
So Amber, that's the second topic. Why do you want to avoid probate? Let's cover the third topic. How do you avoid probate? There are really 2 ways to avoid probate. Number 1, either through legal documents and setting up something like a living trust, or the second way is to implement strategies. And those strategies would be who owns assets and who's entitled to receive them as named beneficiaries.
Give us some examples of these types of strategies.
Well, Amber, you mentioned one earlier. If you own an asset with joint tenants as right of survivorship, Amber and I own our real estate together. I pass away, Amber still has 100%. So there was no probate there. But now when Amber passes away, absent some other mechanism, then that property would go through probate because there's no owner there and there's no named beneficiary. So one thing would be having a living trust own that real estate is one option to avoid probate. We're not going to get into living trust now. There'll be a second video. But let me give you another example of a strategy, Amber. So retirement accounts, classic example. They're owned by only one person. But they should have a named beneficiary. So my retirement account states, upon my death, Amber will inherit my retirement account. So as long as Amber's here, no problem. If Amber's not here, we've named the children to inherit. So as long as there's someone there to receive it, it will not go through probate.
So what should people do then who are kind of new to estate planning and don't really understand joint ownership versus probatable assets? What do you recommend for your clients?
Well, you can certainly call us. That'd be one thing. But the biggest thing I tell people, Amber, is check your beneficiary designations. There have been court cases after court cases after court cases that say the beneficiary designation trumps everything. So if you were married at the time you started your retirement account and you named an ex-spouse as your beneficiary, and 20 years later you pass away and you're remarried but haven't changed the beneficiary, your new spouse does not get those assets. The ex-spouse does. So the biggest thing we tell our clients, people we are helping, is check those beneficiaries. In our office, we are routinely every 2 to 3 years checking the beneficiaries on all of our client accounts to ensure that they are up to date and accurate. So that's one big thing to avoid probate, is make sure you have beneficiary designations on accounts that allow them.
Besides retirement accounts then, what are some other things that might have a named beneficiary?
Well, so a brokerage account, maybe an individual or jointly owned, can have a transfer on death, a TOD, which says upon your death, then we'll have these beneficiaries. Or a bank, you can have a payable on death, POD. Payable on death for that account can also be set up. So you can do those type of things without fancy estate planning, without attorneys drawing up wills or trusts, those type of things. Those actions, naming a beneficiary on your accounts, will take care of the largest portion of your estate avoiding probate.
And now if you're thinking, but what about my real estate? Don't worry, we're going to do another video on living trusts. But if you want to talk to us before then, you have more questions, you can go to workwithnewgen.com and make an appointment with us.
Yeah, schedule a 15-minute phone call, see if we can help you in some way, because we want to help you make the rest of your life the best of your life.
Plan now to retire happy.